So we're going to get started. So essentially what happened this afternoon is that ICE announced what I would call kind of like a multi-pronged structure. And it essentially included a new memo on the exercise of prosecutorial discretion. It was kind of a memo that was long overdue. The last general memo, and that was 10 years ago, the Meissner memo. And the new memo has something very interesting to say about the Meissner memo. A specific memo, separate, on prosecutorial discretion for victims, witnesses, and plaintiffs, victims of domestic violence, and witnesses, and victims of civil rights abuses. A new detainer form, a memo from civil rights and civil liberties with respect to a complaint process under secure communities. And we're going to talk about these things, and we're going to kind of have a general discussion about what each component is and why it's important. So let's start right away by talking about the prosecutorial discretion memo, the general memo first. So David, what does this mean when we go into our offices on Monday? What does this mean for our practices?
Okay, I think this is a big deal. I think you're going to be seeing a lot of different things in the newspapers, most of which are what we're seeing so far by looking at the press reports are focused on secure communities. The prosecutorial discretion memo, the memos that were issued today, are separate and apart. They're related, of course, too, but they're separate and apart from secure communities. So start off there. It's significant, and we'll get into the reasons why, because the language that's used, the factors that are indicated, as I read these memos, give specific standards, hopefully consistent standards, to be applied across the country in the broad use of prosecutorial discretion. It is clear, and we'll point out, from reading the memos, that they take into account students that would qualify for the DREAM Act. Those very same standards are in there. And I believe that I think it's a really good first step. This is a really important memo, despite the criticism you may hear. I think once you sit down and read these memos, it's a really good thing. And we have to give credit where credit's due. Obviously, the proof will be in the pudding. Will it be implemented in the field? That's been a problem, obviously, forever for us. But in talking directly to the director, as we did yesterday, and reading the memorandum, it seems that this is a real effort by the agency to put power, discretion in the hands of agents, field agents, special agents, ICE trial attorneys, to actually make decisions in the field regarding prosecutorial discretion. So I'm talking in generality, and we'll get into the specifics. And then, like Laura said earlier, these memos are available on the AILA website, on the Infonet. We had them up shortly after they came out, and I would encourage everybody to read them. One important thing, if you take a look at footnote number 1.
Yeah, talk about footnote number 1.
Let's put this in context first. And I apologize if this is going to be a little rough, but as you all know, this hit about 2 hours ago, so we're sitting and typing up outlines. But I want to make sure we have this in context. Now let's remember, in terms of prosecutorial discretion, where this sort of came out in the first place was about the year 2000 with the Meissner memo. And that was, a decade ago and an agency away. And as that's faded in time, the directions of that memo really kind of went out of the vocabulary of this more enforcement-oriented scheme. We recently had, the Howard memo, where sometimes you can terminate cases and it depended whether your OCC office was responsive or not, or whether you had a pretty-looking respondent, et cetera. Those types of cases, there was wild discrepancies in terms of how things are being handled. So we have been pushing ICE through your liaison for the last several years, trying to get them to adopt a more uniform policy of prosecutorial discretion, one that covered a multitude of ills, and these documents actually go a heck of a long way towards achieving that goal. As David said, the permission, the direction is here and clear from the memoranda, but the real question we're going to have is when this basically hits everybody's desks, how are they going to actually respond to it? So we will be requesting your feedback. We're going to want to know that if you made a request and you follow all of these instructions and you put all of the factors that they want to see into your request and they still say no, we need to know about that.
More if they still say no, but if they still say they don't have the authority to say yes, that's extremely important, because the key here is to have the folks in the field making some decisions. And you'll see it speaks in terms of decisions being made in the field.
And the other finer point here is that a lot of the response to this has been couched in terms of that this is not going far enough in terms of ESCOM. And obviously nobody's in favor of the Secure Communities program. What I think the hope is here, if we are not making significant headway at this point in terms of getting that program out of the vocabulary of the ICE enforcement lexicon, can we moderate it? Can we temper the effects of it? And in theory, if we have a system that is producing 57% of those arrests are people that either have no criminal conviction whatsoever or minor traffic offenses, if we marry ESCOM to the directives that are contained within this grant of prosecutorial discretion, then we might begin to see some interesting things.
Some interesting good things.
Just interesting. We'll just leave it at interesting. Come on, we're slightly simple.
Well, I think
So what kind of remedies can be offered within the world of this new prosecutorial discretion?
Well, if you got David and I hyped up on caffeine and said, what are all the cool things that they should be doing? We might actually come up with this list. It is pretty broad. They can issue or cancel detainers. They can issue, reissue, serve, file, or cancel NTAs. So that sounds suspiciously to me like all those nice cancellation cases you have where they served your NTA at 9 years and 7 months, that it might be appropriate, if they meet the factors, to request that that NTA be canceled and reissued.
so that you can get cancellation after 10 years.
They will potentially focus on particular conduct, so on the negative side, you might see some of these things where they're targeting sex offenders or a certain type of violator. They can make decisions on who to actually detain or release on bond, or on an order of supervision, or whether to release somebody on an order of their own personal recognizance, or other conditions of release.
And that's significant, because how many of you have had a client arrested under a final order? Well, I can't do anything, he or she's under a final order. This doesn't give anybody any rights, remember that. But it gives you the authority, the ability to walk in there and say, hey, wait a minute, this guy that you had under a final order because they missed their hearing, because they didn't get notice, or whatever it is, this person does not fall within the enforcement priorities, and by your own memo, you need to consider
They have
supervised release.
They can decide whom to stop, question, or arrest, as opposed to having to grab everything that walks by. They can look at alternatives to 240 proceedings. This could be potentially negative in a situation where they might attempt to do administrative removals or seek stipulated removals. They can look at granting deferred action, granting parole, or staying final orders, agreeing to voluntary departure, the withdrawal of an application for admission, or any other action in lieu of obtaining a formal order of removal. Whether or not to pursue an appeal, whether or not to execute a valid removal order, and responding or joining in motions to reopen, as well as joining in a motion to grant relief or other benefits.
And what is the group of people who are authorized to exercise this discretion?
The group of people, Eleanor, is fairly broad. It goes down right into the field. If you take a look on page, So I think it's page 5 of the memo. You'll find that the group of people that can authorize are removal officers, folks special agents, Office of Principal Legal Advisor, which would mean the Chief Counsel, or the Assistant Chief Counsel, folks in the courtroom. ICE at the attorney level, including, and they can do this at the EOIR level, all the way up through the Courts of Appeals. Right? So they still have jurisdiction to do it, or the ability to do it, while your case is pending in your circuit. So if you've got cases pending up there, if you've got cases pending before the board right now, take a look at this memo very carefully.